This report is in respect to a recent Supreme Court of Canada decision referred to as Schrenk. It was issued in 2017, listed as SCC number 62. It is actually an appeal of an original BC Human Rights Tribunal decision, and the tribunal was launched through an application issued by a complainant who was essentially an engineering consultant providing services to a construction site where through the course of his duties he had to interact with a number of stakeholders and construction and project management individual who were employees of employers other than his employer. Though that's really not unusual on a construction site. There's lots of technical and operational consultants and professionals on the site who are employed by multiple entities, all working on the same site, trying to get the same project completed. Now, the complainant, through the course of his duties, was subjected to status discrimination along the lines of place of origin, religion, and sexual orientation, both in his direct interfaces with Mr. Schrenk and also through derogatory emails that he would receive from Mr. Schrenk. Ultimately, things didn't go so well, as you can imagine, and the complainant ultimately filed a human rights complaint against Mr. Schrenk and his employer, and both Mr. Schrenk and his employer sought to have the complaint dismissed on the basis of there being no employment relationship between Mr. Schrenk and the complainant, or Mr. Schrenk's employer and the complainant. This made its way through up to the BC Court of Appeal, to the BC Supreme Court, and then ultimately to the Supreme Court of Canada, where the Supreme Court of Canada came to the conclusion, or offered the statement, that the Human Rights Tribunal in this case needed to look at a number of relevant factors, and one of which was there was a nexus or a connection that was created by the fact that the complainant, through the course of performing his duties, his services to the site, which is rationally connected to his employment, necessarily had to have these ongoing interactions with Mr. Schrenk and Mr. Schrenk's employer. And the result of that is through the course of the complainant's employment or servicing his obligations to his employers, he would have been subjected to repeated affronts to his dignity. Therefore, the connection was established, and the Supreme Court of Canada would allow the complaint to proceed. So the implication for employers, I don't think it breaks anyone's heart in this fact set, but the implications for employers is that employers are very clearly, at least in British Columbia, liable for the conduct of their employees and how that conduct may or may not interfere with the human rights of individuals who are not employees of the employer. Now, I would like to note, at least, the BC Human Rights Act is drafted such that it states that persons may not discriminate, quote unquote, persons, and whereas this would be in contrast to, say, the Alberta Human Rights Act, which states that employers may not discriminate. There's been a divergence between the two provinces in respect to how broadly the Human Rights Acts apply in each of those provinces. Having said that, In regards to this particular fact set, I mean, bad facts make bad law, and there's a lot of reasons that an employer would want to intervene and govern the conduct of their employees in this matter. And there could be liabilities arising from a number of different sources, including occupational health and safety violations potential, even workplace compensation in the event that things escalated to a violence or a health matter as a result of the behavior. There's a lot of reasons why an employer needs to manage this issue. And of note, policy drafting that we were involved with the Construction Owners Association of Alberta, Respect in the Workplace policy, we recognized this factor and nuance on construction sites very early on, and purposely wrote that policy as to be very expansive to, in fact, oblige employers to act in the event that individuals outside of their employment are either impacted or are impacting the welcoming and respectful work environment of their employees. And we did that so that employers would actually have ammo, if you will, to approach clients or subcontractors or contractors that are performing work across a different silo of scopes. If a policy is written in an expansive way, like the Respect in the Workplace policy, it actually gives a basis to start the discussion on a site in the event that there's harassing behavior or unsafe work environments created by individuals who are strangers to the employment relationship. In addition to this, it's further important, especially as it relates to respect, bullying, harassment escalating to a violent scenario, which some of the literature would state that that is the case. It is useful to note that over 90% of workplace violence fatalities directed towards women are actually conducted by individuals who are actually strangers to the work site, at or around the work site. And so there's a lot of reasons to have expansive policies for employers to step up to the plate and not shy away from the responsibility of ensuring that their employees' behavior as it relates to strangers to the workplace, and also strangers to the workplace's behaviors and their potential negative impacts on their employees, be in fact managed, governed, and dealt with. If you'd like to have more information on this or have a specific case you'd like to discuss, please contact us at www.workforcedelivery.com. Thank you.